Welcome to the Pennsylvania Case Law Update While You Drive podcast. You give us less than 20 minutes per week, we will make sure you never miss changes in the law. This week's episode is brought to you by the McShane Firm. For nearly 20 years, the attorneys of the McShane Firm have been trusted by our neighbors and our friends to represent them in DUI and criminal law cases.
Thank you for joining us for episode 16 of the Pennsylvania Case Law Update While You Drive podcast. I'm your host, Katie McShane, and today we're covering cases decided between September 30th, 2020 and October 6, 2020. We start this week with a civil litigation case. In Khalil versus Cole, Cole was the attorney for Khalil in a civil action in 2009. In 2013, Khalil filed a lawsuit against Cole and her law firm for fraud. Cole filed a motion for summary judgment, which was granted, but is currently on appeal. In the instant case, Khalil filed a second lawsuit. The case was dismissed on grounds of res judicata, and Khalil appealed. Res judicata is a legal doctrine which bars relitigation of issues that have already been determined in court. For res judicata to apply, there must be 4 common elements between the two actions. 1. Identity of the thing sued upon. 2. Identity of the cause of action. 3. Identity of the parties. And 4. Identity of the capacity of the parties. The court here found that all the elements were met. The only difference between the two cases is that in the first action, Khalil sued for a little bit of fraud. In this current action, Khalil is suing for more fraud. However, the court finds that the lower court properly determined that this lawsuit is barred by res judicata, as all 4 common elements are present between this case and the 2013 case. The courts issued several criminal law opinions this week. In a somewhat confusing opinion, the Supreme Court in Commonwealth v. Hill addresses double jeopardy and illegal sentencing in a DUI case. In this case, the defendant was convicted of 2 counts of DUI. He was sentenced to 3 to 6 days jail, followed by 6 months probation on 1 count, and the court entered a finding of guilt with no further penalty on the 2nd count. The defendant filed post-sentence motions but never raised the double jeopardy claim. Here, the court declined to address the double jeopardy claims raised by the defendant, as they found the sentence on the 2nd count illegal on non-constitutional grounds. The court found that a sentence of a finding of guilt with no further penalty is an illegal sentence when the charge carries a mandatory minimum sentence. Here, because the 2nd DUI count also carries a mandatory minimum sentence, the court vacated the sentence but declined to vacate the conviction for the 2nd count, holding that the defendant waived the claim as to a conviction for failing to preserve the issue prior to appeal. He was only permitted to raise the question of the illegal sentence because that issue cannot be waived. This case is a bit of a head-scratcher, as we are left wondering what the practical implications are when there are 2 convictions for DUI under the same subsection of the statute. I guess we will have to wait and see how the court rules in a case where the issue is properly preserved. In Johnson v. Wetzel, the defendant is claiming that the prison violated due process by deducting costs and financial obligations from his inmate account without proper pre-deduction notice. Here, the defendant was sentenced to a period of incarceration as well as costs in the amount of $1,166. Pursuant to Act 84, the prison can take deductions from an inmate's account to satisfy the financial obligations of his sentence. The defendant's first deductions were taken in 2013. In 2014, the court ruled that due process requires an inmate be given notice of the department's Act 84 policy, the total amount owed by the inmate, the rate at which the deductions will be taken, and which funds are subject to deductions. As the first deduction took place before the court announced the pre-deductions requirement, the court must determine if the defendant is entitled to relief. The court found here that where pre-deprivation due process is unavailable, post-deprivation remedies can satisfy due process. The court concluded that the record is insufficient to determine if the defendant was notified of the required information at any time during the process. The case is remanded to further develop the record, and if proper notice had not been given, the department must give notice as required under the law. The defendant also alleged that he was entitled to an ability to pay hearing. However, that hearing is only required when an inmate has a change in circumstance affecting his ability to pay. Such is not the case here, as the defendant has failed to establish any change in his circumstance. Commonwealth v. Weir addresses whether restitution amount is a discretionary aspect of sentencing requiring that the issue be preserved for appeal, or an issue of legality of sentence which does not require preservation. Restitution is required to be ordered pursuant to statute when the requisite conditions are met. However, the amount of restitution is a discretionary aspect of sentencing and to be determined by the judge based on a number of factors. If restitution should have been ordered and was not, or should not have been ordered and was, that would be a question of sentence legality which is not required to be reserved for appeal. If the question is to the amount of restitution, it is discretionary and therefore must be preserved for appeal. In this case, the defendant is contesting the amount of restitution owed, but failed to preserve his claim, and it's therefore waived, and he is not entitled to relief. Commonwealth v. Small addresses the public record exception to the PCRA 1-year time bar. It is necessary to discuss previous precedent to explain the ruling in this case. First, a PCRA petition must be filed within 1 year of the date a case reaches final disposition. There are 3 exceptions, one of which is newly discovered evidence. In the event of newly discovered evidence, the petition must be filed within 60 days of discovery. The public record exception has held that when the newly discovered evidence has been a matter of public record, it is deemed to be known by the petitioner. Further case law found that because inmates lack the access to public records that ordinary persons possess, the public records exception does not apply to inmates. In this case, the Supreme Court overruled their previous precedent, holding that the public records exception does not apply to anyone. The court stated that their previous case law improperly expanded the plain language of the statute in which the petitioner must only prove that the facts were not known to him. There is nothing in the statute that even alludes to information that is in the public record, and therefore the court overrules all previous case law upholding the public records exception. This is a dramatic departure from previous case law, but the court finds itself compelled to correct its previous error. In this particular case, however, despite the change regarding the public records exception, the court finds that Small is not entitled to relief as the record does not support the statutory requirements necessary to obtain relief under newly discovered evidence exception to the 1-year time bar.
This segment of Pennsylvania Case Law While You Drive podcast is sponsored by the McShane Firm. The McShane Firm is Pennsylvania's largest and best DUI and criminal law firm. Their mission is simple: make sure the presumed to be innocent remain innocent.
We'll start the second half of our show with an ethics opinion. Sivick v. State Ethics Commission addresses ethical violations and conflicts of interest. Sivick was a township supervisor who wanted his son to have a job. There was a nepotism policy in place that had to be eliminated in order for Sivick to get his son a job with the township. The provision was eliminated, and Sivick's son was given a job in the Public Works Department. An ethics investigation was eventually instigated, and Sivick was found by the commission to have violated the ethical rule against conflicts of interest. Only 2 issues are addressed by the Supreme Court in this case. 1, whether Sivick signing off on payroll to the Public Works Department that included his son is a conflict of interest, and 2, whether restitution can be ordered when the beneficiary is not a public employee, but rather a family member of a public employee. A conflict of interest is defined as use by a public official or public employee of the authority of his office or employment for the private pecuniary benefit of himself or a member of his immediate family. It does not include an action having a minimal economic impact or which affects to the same degree a class consisting of the general public or a subclass consisting of an industry, occupation, or other group. In this case, the Supreme Court found that Sivick's son was a member of a subclass, and therefore Sivick's overseeing his payroll was not a violation of the conflict of interest. The court ruled this way primarily because Sivick did not set the payroll, and his actions were the same to all employees of Public Works Department. As to the question of restitution, the law states that restitution can be ordered when a public employee gains a pecuniary benefit. The language "or immediate family member" is missing from the statutory language. The Supreme Court found that this omission was intentional, and because the language of the statute is not ambiguous, the lower court erred by imposing restitution. The case is remanded to the Commission to determine if there is still a basis for a conflict of interest violation, and if so, to fashion an appropriate remedy which does not include restitution. The next case addresses municipal law. Seda-Cog Rail Authority v. Carload Express addresses the Municipal Authorities Act to determine whether the language of the Act overrules common law in regards to a majority vote by board members. Common law requires a majority of voting members to carry an action. Members who are present but do not vote are not counted when determining a majority. In the Municipal Authorities Act, the language states a majority of members present. In other words, are 9 votes, which is a majority of the members present, though 6 abstained from voting, required to take action, or conversely, are 7 of the 10 votes actually cast sufficient? The court found that pursuant to statutory construction, there is a presumption that the act constitutes a codification of common law, and there is no basis to conclude that the language of the statute clearly and definitely abrogates the common law voting standard. Under the common law, the phrase members present means voting members, as non-voting members are not present for purposes of calculating a majority. The Act incorporates the common law rule that when a quorum is present, a quorum being the minimum number of members necessary to have a vote, action may be taken by a simple majority of the quorum unless more votes are cast than the quorum number, in which case a majority of the votes cast carries the action. Therefore, the 7 votes out of the 10 voting members is sufficient to carry the action, and the 6 members who abstain from voting are not counted as members present. In the final segment, we have 2 tax law cases. In Fouse v. Saratoga, the petitioners contest the constitutionality of the real estate tax sale law, claiming that the disparity between that law and the Municipal Claims and Tax Liens Act violates equal protection. Under the Municipal Claims Law, which applies to first and second class counties, when a property is sold at a tax sale, there is a right to redemption if the property taxes are paid in full within 9 months. Under the Real Estate Tax Sale Law, which governs counties of second class A through 8th class counties, there is no such right of redemption. However, under the real estate law, a property owner has the opportunity to prevent the sale if they can pay 25% of the tax burden prior to the sale and pay back the remaining 75% within 12 months. Equal protection demands that uniform treatment be given to similarly situated parties. Our constitutions have long been interpreted to permit the legislative branches to draw classification so long as they are properly justified. The petitioners argue that the asserted right is a fundamental right requiring strict scrutiny and a narrowly tailored law. The Pennsylvania Supreme Court finds that it is not a fundamental right, but rather a statutory remedy provided as part of a legislative tax collection process, and as such, only rational basis review is required. Under rational basis, the law must be only rationally related to a legitimate state interest. The legitimate state interest in this case is that of collecting property taxes. Further, the purpose of the real estate tax sale law is to expedite the collection of delinquent property taxes, to retain the productivity of the real estate, and to maintain economic value. The court finds that the lack of redemption in the real estate law promotes the legislative interest in facilitating the collection of delinquent taxes by ensuring certainty and finality for tax sales, which in turn likely encourages higher bids based on the greater security provided to the purchaser. Under rational basis review, the lack of a right to redemption does not violate equal protection. The appeal of Chester-Upland School District involves the taxation assessment of property value when a billboard is placed upon the property. Per the tax code, signage used on the property, including billboards, cannot be assessed as value of real property. In reviewing the relevant statutory sections and similar provisions in the tax code, the Supreme Court found that while the physical billboard may not be assessed as real property, the net income obtained through lease payments and easement payments can be considered in assessing the value of the property. That's it for this week. Thank you again for joining us, and I hope everyone has a great week.
Thank you for listening to the Pennsylvania Case Law Update While You Drive podcast. Be sure to subscribe to this podcast and our YouTube channel to make sure that you are always in the know when it comes to important changes in Pennsylvania case law. We want to thank this week's sponsor, the McShane Firm. The McShane Firm is a central Pennsylvania fixture when it comes to DUI and criminal defense. The attorneys and staff at the McShane Firm believe in good old-fashioned central Pennsylvania values like hard work and straight talking. Give them a call if you or a loved one ever needs help.